Good morning, everyone. We're going to go ahead and get started. We might have people fill in throughout the day, so disregard the opening and shutting doors. So my name is Melany Cruz Burgos, for those who don't know. I'm the current editor-in-chief of the Duke Forum for Law and Social Change. Our journal was created 9 years ago, and the true core mission of it was to basically focus on discussing important, timely social issues that some of the other journals don't do. We really wanted to move away from theory and think a little bit more about practical things going on in our world. When our current editorial board met last May and decided on our topic, I have to admit we didn't realize how timely it would be when we actually hit the ground running and published and had our symposium in the spring. With the election and inauguration of a new president, we've already seen an extreme shift in the agenda on the very issues our volume is focusing on, specifically race, religion, and our border politics. It seems that the landscape continues to shift hour by hour, and buzz phrases that were once relics of our past seem to be uncomfortably contemporary. Thus, as we can all, I think, agree, the dividing lines in our country are much more noticeable than we once thought they were. So I think we're all looking forward to kind of learning more about those dividing lines and focusing on those issues and perhaps having some discussion and Q&A. So it's my pleasure to introduce our first presenter. Her name is Hernandez. She's a tenured professor at Baylor Law, and she has experience with the immigration clinic there. And she does a bunch of other things, so I won't go through all of her activities. But she's going to be presenting on the demonization of immigration, and she has a forthcoming article with us that will be published in the spring.
Thank you, Melany. Thank you. So first of all, I just want to thank everybody in the audience for being here this morning. I appreciate it, and we've got a lot to talk about. You know, some of it is, fast-changing and upsetting, and I just want to thank Melany and the rest of the journal members for recognizing that this topic is indeed very important and very timely, because as I'm going to, assert or argue for during my talk, is that right now it really does seem to me that we are in a battle over ideas. And this is a sort of skirmish that we are not used to in the United States. But really what it seems to be happening here is we need to figure out what America is. In other words, we're really sort of battling for what is America going to stand for. And it's not a narrow sort of issue. What America stands for is happening, it's reaching many, many areas and many, many areas of policy. And I guess the thing that's very unusual is that in the law, sure, of course, we always have policy matters, but they have sort of been shifted to the forefront of the political landscape. And now we begin to see that when we are talking about policy, that sometimes the black letter rule of law doesn't help us figure out in an objective manner how we should approach it. And so one of those areas that has been shoved to the forefront, of course, is immigration law. And immigration law, for those of you who have taken the course or for those of you who have any interest in it, is very policy-driven. So the very first thing you've got to remember about immigration law is that this is a plenary power that is reserved to Congress, okay? So Congress supposedly has the last word with respect to our immigration laws. Now, why is that? Well, because immigration touches on things that are foreign policy related, that deal with issues of sovereignty, that deal with, how the United States chooses to govern itself and its actions with foreign countries. So Congress was invested with the authority to make our laws. And in fact, as I will talk about a little bit later, the United States Supreme Court has consistently deferred to Congress and congressional opinion on how to deal with immigration laws. But before I get into that, where I wanted to start with is this past presidential election and the rhetoric that was associated with immigration and America's immigration policies. Now, for my part, I was very, very shocked at the very crass language and the fear-mongering, so to speak, that happened on the political trail with respect to immigrants. And the fear-mongering wasn't simply aimed at Latinos. It was aimed at Muslims and basically anyone who was affiliated with certain parts of the country. And for my part, I really didn't think that rhetoric was going to have much traction. I thought, this is the bad way to go. We're in a country where the Latino representation is getting bigger by the minute, and I expected that our politicians would reflect that reality and say, okay, well, we're not going to say anything like deport them all or build a wall, and have that really have any sort of traction. And then, of course, the election turned out the way that it did, and in retrospect, it seems that that sort of rhetoric had a lot of traction with certain portions in the United States. So if you remember, back in 2004, John Edwards, when he was running for vice president with John Kerry, talked about the two Americas. Right, and that was his campaign slogan, that there were two Americas that needed to come together. Now, when in 2004, we, or at least I always assumed what we were talking about were the economics. So in other words, the haves and the have-nots. What I think everyone failed to realize back in 2004 is that the two Americas were actually, it went far beyond simple economics. Now, my research assistants and I compiled some data, and we were trying to figure out, well, okay, most of the political commentators after the election said, oh, it was the Rust Belt. The Rust Belt were the voters that came out for now President Trump and basically handed him his office. And so when the discussion happened, I started wondering, well, okay, so the Rust Belt was one of the main factors towards the presidential outcome. And people are saying that it's mostly economic, but is that really the case? Is simple economics, was that what was powering that particular voter turnout? And what we found going through several states that were in the Rust Belt and just taking numbers from counties, both rural and urban, small and large, and just doing a random sampling and trying to see what is the level of diversity in those counties and what is the income. What are their income? Is it the fact that they were struggling economically that caused them to shut out everything else and focus on that simple one campaign platform? And what we found out in actuality is that diversity drove that particular, the particular outcome of the election. So in other words, if those counties had 90% white alone, non-Hispanic voters within their borders, they went overwhelmingly for Trump. So if it were 90% and over, it was for Trump. It did not matter with respect to their income. It did not matter with respect to their education level. If the numbers were more in the 70s and 60s, those counties went for Clinton. Now, the only county that was a little bit of an anomaly was this Douglas County in Wisconsin. So if we look, what we see is that in this particular county, we have, in 2015, white alone, not Hispanic or Latino, 93%. Going for Clinton, 50.49%. So obviously very, very close. So this particular anomaly, though, I think can actually be explained by the level of education. So out of the entire population of Douglas County in Wisconsin, 22.5% had a BA or higher. So what we kind of started to see is when we had a little bit of anomaly, if we looked to see what the educational level was, that sort of informed where the vote went, so to speak. So when I started to think about that, I thought, you know, I always try to stay away from, you know, like these broad labels, like, oh, well, all these people are racists and things of that nature, you know, because that, frankly, you know, doesn't help anybody. So then how are we going to explain this? And I actually believe it's fear and a lack of understanding, right? Lack of the known. And when I think of it that way, I can't help but feel just a little bit sad because that has been the narrative in immigration law since the 1800s, probably since the 1700s, but I can't really document that. But since the 1800s, that this fear of the unknown, fear of segments of population that we do not know very well, either because they look different, they practice a religion that is different from ours. This fear has been a motivating factor in United States policy since the late 1800s. And look, everything old is new again. We're doing it again, which is quite frustrating. So, okay, so what I would like to do at this point is start at the beginning. And in the mid-1800s, that is when immigration law really started to exist. Up to this point in time, we had no limits on people who came to our country simply because the United States was a young country, it had a lot of land to settle, and the more American citizens who settled it and claimed it for our country, the better. So there were very few checks on the border. That all changed in the mid-1800s because what happened at that point in time was there was a need in the United States for cheap labor because we were building the Transcontinental Railroad. And when those railroad barons looked around, they said, well, where can we find this labor source to do this very hard work that most people don't want to do because it's dangerous and you might die? They actually latched onto a labor force from China because China was in the middle of a civil war. So people were fleeing, they were coming to the United States, and they were the cheap labor force that wasn't quite so picky about working conditions and pay. So the Chinese got to work on the Transcontinental Railroad. When that was done, there was no job for them to go to. And on top of that, the United States immediately went into a recession. So the United States economically didn't have a lot of job opportunities. They had this huge labor force that they didn't know what to do with. And on top of that, this huge labor force looked different from all the European migrants. They worshiped differently, and they did not readily learn English or adapt to the then sort of European customs in the United States. And this made a lot of people hostile and angry. And what happened was that Congress decided to pass a lot of statutes, in essence, either stopping migration only from Asian countries and making it very difficult for those Asian migrants who were here. And this led to a case that you will often hear referred to as the Chinese exclusion case. Now, this is important right now because with the executive order that is now on appeal up to the United States Supreme Court, banning certain entrants, non-citizen entrants from those 7 countries, people are talking about the Chinese exclusion case. And so here is what you have to know about this particular case. This was a landmark Supreme Court case where the United States Supreme Court basically said, hands off. We are not going to interfere in congressional decisions regarding immigration laws, which is extraordinary. I mean, and if all of you have had constitutional law, which I'm pretty sure you have, you know how extraordinary that is. Because when the United States Supreme Court wants to decide something, it is amazing how fast they give themselves jurisdiction, right? We're not going to let little, problems with maybe jurisdictional mootness get in the way. We're just going to, drive right in there. So when you look at the 1800s and having the United States Supreme Court going saying, oh, we really don't think we should be looking at this, it's quite extraordinary and, clearly something from the 1800s. But what was the reason that the court gave for saying whatever Congress wants to do is fine? Well, of course, they talked about sovereignty. They said, the congressional authority and presidential authority, executive authority, they're the ones that really need to decide who's going to come in and who is not going to come in. We can't interfere with that. That's not really a judge's role. Then they talked about what at that point in time was a license. And so what the modern day equivalent of that is the green card or the visa. They said, sure, we are trying to exclude people who might have a visa, but you know what? That visa was handed out by Congress. And if they want to take it back, it's absolutely their decision to do that. Now, what were the underlying facts of the Chinese exclusion case? They might sound very familiar to you. We had Mr. Ping, who had lived in the United States for many, many years as a non-citizen. Now, the other important thing for us to remember is during this time period, if you were Asian, you could not naturalize. You were actually barred from naturalizing. So the best you could hope for was to be a lawful resident, a green card holder. So Mr. Ping had been in the United States, fine, upstanding resident, here lawfully, and he decided, I want to go back home and visit some of my relatives in China. Now remember, this is the 1800s. You don't get to China very easily. It takes weeks to get there, and so you stay for a little while, and then it takes weeks to come back. And at the time Mr. Ping decided to go back home and visit, Congress had said, we'll let you do that as long as you get the equivalent of a reentry permit. If you get this reentry permit and you leave and you come back, we'll let you back in. It's okay. So Mr. Ping goes on his trip, and on the boat ride back, Congress passes a law or passes a statute that basically revokes that reentry permit. They said, we don't care. We don't care if we said you could come and that you're in transit. Does this sound familiar? That you're in transit and you have fulfilled all the requirements. We are not going to let you back into the country. And so they excluded Mr. Ping. Oh, by the way, he missed it by 2 days. So he landed 2 days after the statute went into effect. And so he, asked the Supreme Court for some sort of relief for this. And so this was why the Supreme Court started backing off and saying, well, sovereignty, and oh, by the way, that license that Congress gave you, the visa, it's at their discretion. If they want to take it back, they can take it back. And then finally, the court says, we think that these sorts of decisions are reserved for, at the time they called, the political department, otherwise known as the executive branch and the legislative branch. Now, this exact argument, is the argument that the president and the Department of Justice are making with respect to this executive order. So what their prime argument was, and if you listened to the arguments before the Ninth Circuit, basically talking about staying the travel ban, their primary argument to the three justices on the Ninth Circuit was this: the president can do whatever he wants because that is a matter for the executive branch and sovereignty issues. And they didn't say this outright, but they implied it very, very heavily. They said that anything he chose to do in this area of the law should be judicially unreviewable. So that don't talk to us if you don't like it, courts, because you've stepped away. And so where are they getting the source for this type of power? Well, the Chinese exclusion case. because the Chinese exclusion case has never been overruled. Okay, so just so that you know that this wasn't just a case the Supreme Court ruled on sort of, in a bubble or doctrinally, here is some of the language that was used to justify this particular decision by the Supreme Court. And it was written by Justice Field, and the court themselves seemed to take a lot of issue with the way these Chinese immigrants were living in the United States. They were really upset that they didn't always know English and that they dressed in their traditional Chinese clothing. And this was very upsetting to the European American citizen, right? Now, it always makes me laugh about not knowing English because I come from an immigrant family. So my mother was born in Mexico. And so a lot of my aunts and uncles came over from Mexico to this side, back around the time of the Depression. So I remember that there were a handful of my aunts and uncles who never learned English. I don't know why. Maybe they were too old. Maybe they found that they could get around without having to learn a second language. Lord knows I would not do well if I had to learn another language at this point in my life. It would be very, very sad. But you know who does learn the English and who does assimilate? It's the children, right? The children always assimilate. And I want you to think back to when you were in grade school and middle school. The last thing you wanted to do was stand out, right? Let's remember that. Like, oh, no, I want to be just like everybody else. So it's always the children of these immigrants that do assimilate. It's that first wave that has a little bit of trouble. And indeed, that's what was happening here, that the people who were older, who were the first wave, were trying to keep a part of their culture, and were probably just a little bit, afraid themselves of being in this new place, and this was causing fear and paranoia. And so when we see what Justice Field actually says, he says, if therefore the government of the United States, through its legislative department, considers the presence of foreigners of a different race in this country who will not assimilate with us, by the way, that wasn't necessarily true, to be dangerous to its peace and security, their exclusion is not to be stayed because at the time, there are no actual hostilities with the nation of which the foreigners are subject. So the argument had been to the court is, we're not at war with China. Why are you excluding them? There's no reason for you to be treating these Chinese migrants this way. And the Supreme Court says, hey, that's for the executive and Congress to decide. And there doesn't need to be a war. So, all right, let's flash forward now to 2017 and the 7 enumerated countries. We are not in hostilities with those countries, but they've been deemed terrorist countries. And so, once again, the administration is saying, we don't need that kind of evidence to decide we are going to exclude certain types of non-citizens. So, all right, so now I'd like to flash forward a little bit to the mid-1900s and World War II. Now, when World War II is discussed, it's usually a point of pride for our country, and rightfully so. Defeating the Nazis was a very, very important thing. But we can't fail to remember some of the things that happened on our shores as a result of very, very frightening, I guess, paranoid, response to national security. So, if I could at this point in time, I would like you to start thinking about how often national security is proffered as the reason for treating certain non-citizens in an exclusionary way or in a lesser way. So, with the Chinese exclusion case, what we had there was fear, maybe not necessarily national security, but failure to assimilate, big giant X. So now we're in World War II, where now we are in a war. There is a national security threat. And so what happens during World War II is that our government decides, and once again, we see the Asian migrant being treated very, very badly. The American government saying, gee, if you're of Japanese descent, we can't trust you. We don't know that your first alliance is to the United States. And if your first alliance is not to the United States, how do we not know that you won't be feeding information back to the homeland, to Japan, who we were at war with? Now, this wasn't just Japanese non-citizens. These were also Japanese Americans that were interned. So they were, in essence, moved out of their houses. Many, many times, these Japanese American citizens' assets were seized and were never recovered after the war and placed into internment camps for purposes of national security and to make America safe. So what I did was I actually got a copy of that particular executive order signed by FDR so that we could see what some of the language was and some of the justification for creating the internment camps. Yay, there it is. So if we read this language, again, once again, this is beginning to sound very, very familiar with respect to what the current executive order says. And, but here's the thing, though. At least FDR had a war. I mean, there was a war going on. We were in hostilities with Japan, but the justification for the internment sounds very, very, very familiar. So whenever there is a declared war between the U.S. and any foreign nation or government, or any invasion or predatory incursion is perpetrated, attempted, or threatened against the territory of the U.S. by any foreign country or government, and the president makes public proclamation of the event, all native citizens, denizens, or subject of the hostile nation or government, being of the age of 14 and upwards, who shall be within the United States and not actually naturalized, shall be liable to be apprehended, restrained, secured, and or removed as alien enemies. And it goes on. It goes on basically saying, well, you know, our national security is at risk. We cannot afford to have these immigrants here within our borders. Well, we know that nowadays, that to think that an American citizen might have loyalties to a foreign government, even though they've become a part of our citizen, I mean, that would be very, very objectionable. But back in the 1940s, Asians were still the subject of much, much discrimination. So people believed it. I mean, United States Supreme Court decisions basically said things like, well, you know, we don't know when they take an oath that they really know what an oath means. We can't trust that they won't treat an oath the same way I guess European citizens treat an oath. So therefore, we must treat them with a lot of fear and suspicion because we're unfamiliar with their culture. They don't seem to be assimilating with us. And by the way, many a politician in California made their reputation by uttering and running on very, discriminatory precepts against the Asian community. And one of them was a California governor named Earl Warren. Now, these days, we think of Chief Justice Earl Warren, as a leading figure in civil rights decisions and desegregation, a real, flame holder for those types of expansions of civil liberties. But he didn't begin that way. He began by saying Asian immigrants and Asian migrants needed to be treated differently and needed to, in essence, be precluded from enjoying the full benefits of citizenship or the full benefits of property ownership and things of that nature. So somewhere in his evolution, I think he realized how wrong he got it, and he really sort of did a 180 and became a leading figure in terms of righting those types of wrongs. But So we see this, we're afraid, we're scared, we don't know these people. We have to do something to protect ourselves, and what we are going to do, in essence, is legally suppress a certain part of the population. Which brings us to Immigration Code, Section 212F. Now, the INA is referred to in two types of ways. So a lot of people will refer to the immigration and naturalization statutory sections by the INA site. If you actually want to go onto Westlaw and pull it up, though, that is not the way that you would find it. You would find it by pulling up 8 USCA 1182. So, we've got two methods of citation, which I know sometimes gives my students a lot of frustration, so I try to give both sides. But INA 212F is the statutory language that President Trump is relying on for this executive order to, in essence, be able to unilaterally exclude non-citizens from those 7 countries, right? 7 predominantly Muslim countries. Now, remember what I said at the beginning of this talk. Immigration law belongs to Congress, not the president. The president can write executive orders, and he can sign executive orders, and he can direct executive action. But that kind of authority does have limitations. And we know this for a fact, right? Because during President Obama's tenure, he promulgated the Daca Program, which is Deferred Action Childhood Arrivals. Now, if you're familiar with that Daca program at all, you will know that it never conferred legal status. It only conferred a quasi-legal presence, and it was temporary. So after 2 years, you have to renew, or the program could be sort of destroyed by the signature of a pen as well. All right, so we have to remind ourselves, okay, does the president have a lot of authority? Well, we just saw the United States Supreme Court saying, yes, he probably does, but that it really is a congressional issue. But what does 212F say? Well, this particular section of INA deals with admissibility. So the terminology for whether you're going to be allowed to come into the country is, are you admissible? And you must check all those boxes. If you are inadmissible for any reason, you can't come in. So what might be some of the reasons that would make you inadmissible? Well, maybe you're a hardened criminal, or maybe you're trafficking drugs. There is no greater sin in the immigration world than to be involved with drugs. So whatever you do, don't do that. Maybe you have a national security problem, the way that President Trump has designated these 7 countries. There are different things that can render you inadmissible. So within the very, very large code dealing with admissibility, we have 212F. And what it says is, whenever the president finds that the entry of any aliens or any class of aliens into the United States would be detrimental to the interests of the United States, he may, by proclamation, and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate. Well, that seems pretty broad. I mean, in essence, what this section has said is that he can keep people out who are non-immigrants, so in other words, people who are only coming to visit, and that he can keep people out who actually have green cards, because in the INA, when you see the word immigrant, what they really mean is green card holders. So if he can do this, what was the problem with the executive order, and why is it that we had first the Washington District Court and now the Ninth Circuit saying, no, your authority doesn't go that far? Well, first of all, it's very important for us to remember that it is not unfettered authority. He can't do whatever he wants. He has a lot of authority, but it's not unchecked. Second, it was the nature of the executive order itself, because the executive order basically invoked a national security concern that the administration failed to substantiate. Now, remember, when FDR decided to create the internment camps and to keep certain peoples out, we were at war. So he was well within his authority under the immigration code. And I guess that's the other thing that we all have to recognize, is that the president, in fact, does have a lot of authority. It's just that the current administration overreached, right? So the administration failed to support this national security concern with any real evidence that the court could look at. And also, it really does seem to look like a religious ban. Now, this is very, very important because, again, let's go back to common law. We know the First Amendment, and it says you cannot discriminate against people on the basis of their religion. And there are two parts of it. I can believe whatever I want, you can believe whatever you want, and the other part is that the government can't favor one religion over the other. That's the Establishment Clause. And so what is at issue with this executive order is it really a national security concern that's driving you, Mr. Trump, President Trump? Or is this a religious ban? And of course, the campaign rhetoric up to the signing of the executive order really seems to make it seem as if it's a religious ban. Now, the Ninth Circuit didn't reach that because they're not on the merits yet. They're just really doing this procedural, like, are you going to succeed on the TRO and the preliminary injunction in general? But this is very, very important territory because what is at issue at the merits is, do these non-citizens, and to what extent, do they have the protection of the United States Constitution, specifically that very, very important First Amendment, to request or to be owed some kind of due process before they're summarily excluded? And that's the other thing that we have to remember. We're not saying, nobody is talking about whether or not they should be allowed to stay. What we're arguing about is, shouldn't they at least get a hearing? Shouldn't there at least be due process? This is how far back in the chain non-citizens' rights are, right? And we know why that is. It's because we want to encourage people to be citizens, right? That's the glory of the United States. When you come, we want you to stay and we want you to be part of our country. So there are a lot of incentives put into the immigration code to push these non-citizens towards naturalization. But to date anyway, their constitutional protections are extremely limited. And any constitutional protection we really talk about with respect to non-citizens really only has to do with due process. Like, don't just kick them out. Let them at least have a hearing so that you can figure out whether or not they're a terrorist. And that's sort of what the argument is about these days. So why would we treat non-citizens so harshly and, so summarily? Well, once again, and especially as reflected in this immigration order, everything old is new again. The rhetoric in this country has been to develop a fear of Muslim non-citizens and Muslim citizens, let's be honest. But they're doing something aimed at Muslim non-citizens, and they are the new Asian immigrant. And the Latino immigrants, well, we have our time in the sun too. They haven't entirely pushed us out. There is that wall to consider after all. But, it always seems there's some new group, and a new group in that they're new to the United States. And their ways and their language and perhaps their religious beliefs are different. And the very first thing that many people or certain elements of this country is to be afraid and to try to close borders and to do things that, in retrospect, are quite embarrassing when it comes to history. So this takes me to a discussion on my home state. My home state, our Texas legislature Texas legislature meets, I think, for 180 days every 2 years. And many of us think that maybe even that's too often, because when they get together, they seem to do quite a lot of interesting things. Let us put it that way. So, up until the election of the current president, Texas sort of put itself in the vanguard of challenging the federal government on all sorts of issues, from health care, but especially on immigration law. And so, if you recall, when President Obama attempted to expand the Daca program to allow more people to, again, have that quasi-legal presence, not really status, a lawsuit was immediately filed in the Southern District of Texas, and an injunction was put into place that forbade the program from being rolled out, and in essence basically just killed the expansion of that particular program. So during that period of time, the federal government was bad, and the states needed to be able to pass their own immigration laws, which, by the way, they've never been allowed to do, because immigration is a federal concern. Remember the sovereignty, remember all that sort of stuff. Well, now with this new administration and the ban on the 7 countries, and frankly, we are hearing word of even more executive orders dealing with immigration coming down, and specifically with the DACA holders, which we're all very worried about. With all of that rhetoric, there are, believe it or not, there are a handful of cities in Texas that have decided that they want to be sanctuary cities, i.e. that they are not going to honor what is called an ICE detainer. Now, you can be forgiven if you're not 100% acquainted with these ICE detainers, but in essence, it's this. If there is a possibility that someone who has been arrested and is being held does not have valid residency, that they need to be held in jail until ICE officials can come and pick them up and transfer them to immigration jail, okay? And so it was a requirement that was being imposed on local localities to inquire into status, right? Now, this actually started during the Obama administration. It was an idea called secure communities. And I think at the time the idea was that look, we're going to deport those non-citizens who aren't behaving, who aren't complying with our laws, but we should really be more magnanimous to those who are just living and doing well and doing what they can in the United States. Well, it was a huge disaster as a community, because you know what happened at the locality level? They were detaining American citizens. Why? Because they didn't believe that they were American citizens, and those American citizens didn't have the documentation, their papers, to prove that they were in fact American. So when they asked for the driver's license or birth certificate, they didn't have it. And so guess what? An American citizen stayed in jail for 2 weeks over the period of time that they had originally been arrested for, and was improperly detained because they didn't believe him. And in some instances, they actually had the proper documentation, and that was thought to be fraudulent. So they were detained anyway. So this is America. We know what happened. Of course it was a lawsuit. And so these localities started being sued by these improperly detained citizens and green card holders, and it was costing counties millions of dollars in damages. So towards the end of the Obama era, municipalities were opting out. They were saying, we're not going to do it. Was it because of the love of the non-citizen? No, it was costing them millions of dollars because they weren't getting it right. So secure communities fell by the wayside, but now it's back. It's back in all of its glory, because now it is permissible to have that sort of paranoia towards the non-citizen. And Texas Senate Bill 4, which, by the way, just cleared the Senate floor and is now at the Texas House, so it will probably clear the Texas House. This is what it purports to do. It purports to basically give state law strength to that ICE detainer. And so what we see is it basically says, if you decide to be a sanctuary city, you're going to lose your state funding. And as a matter of fact, Austin, Texas, the sheriff in Austin, Texas, has decided that she's not going to comply with ICE detainers, mostly for the reason that we talked about in terms of getting it wrong and that they seemed very inefficient. So Travis County, which covers Austin, has already lost $1.8 million in state funding, and they're at issue of losing more. To their credit, they're not backing down their crowdfunding for some of these things that they can no longer fund because they've lost that money, one of which was Veterans Court. So there was actually a court that veterans were adjudicated under in Travis County, and now that's gone. But unless they can crowdfund and bring it back. So some of the other things that Senate Bill 4 does is basically says, you will cooperate with federal authorities. Now all of a sudden the federal government is great in the state of Texas. If you've got somebody that you've arrested, you must ask about their immigration status, and if it is not illegal, you must tell the federal government. And oh, by the way, Travis County judges, if you're adjudicating somebody because, they've committed a crime and you've given them a sentence, you should do whatever you can to that sentence so that, even if that means shortening it, so that they can be transferred to ICE custody in a seamless manner. What that means is that they don't have to release the non-citizen, that they go from one incarceration to another. So, again, we're seeming to really, codify at a state level the secure communities. And so what I've given you is like some of the problems with secure communities in the first place. And, other case law that kind of said, hey, just because you're complying with a federal request, that doesn't mean that you can trample on people's constitutional rights. So it's going to be very, very problematic. And so just, going all the way back to the beginning of my talk and this idea of, a battle of ideas, the idea needs to be that we should not be afraid of our immigrants. Our country is great because of our immigrants. We are who we are because of the different people who have migrated to the United States, who worked really, really hard and, taken the country forward. And, for me, it's such low-hanging fruit to convince people of your age that that's the case, because all I really have to do is say, Steve Jobs, okay, got it? Your world would not be what your world is today without that man. and he was an immigrant. And there are so many immigrants who are doing so many great things for our nation. But when we focus, but they're people, and they're not perfect. And when we focus on the outlier crime or the outlier shooting, of course, it's very, very easy to get afraid. But why would you think that not having them in the United States would make you any safer? Because the majority of crime, or at least this, horrific crime that gets covered by the news, is usually committed by either an American citizen or a non-citizen who has a green card to be here. So this idea that undocumented, unauthorized non-citizens are within our borders, raising havoc, putting us at danger, is simply not true. Oklahoma was not the result of a non-citizen. And most of the other crime that gets covered are not perpetrated by non-citizens either. So I wish that we could change this pattern. This rhetoric is getting dull. Please find me something new to be, concerned about. How often are we going to do this? And so again, if we go back to the data that I began the talk with respect to which of these counties seem to vote for President Trump in overwhelming numbers, they've isolated themselves. And when you don't have diversity, economic recession follows. So why is it that they don't have jobs in the Rust Belt? It's because they're not particularly diverse either to new types of people or new types of ideas, and it's killing them. And instead of recognizing that they need to integrate and to change, they're hoping to bring back a version of America from the 1950s. And I hate to be the person to tell them that is never going to happen again. We've been given too many rights now. Women can be educated. Immigrants and people of color can also achieve their dreams as well. I'm a shining example of that. So that's not going to happen. So in this war of ideas, I think that we are obligated to keep talking about all the important contributions that immigrants and non-citizens make to our country, because if we don't change that rhetoric, it's just going to go on and on again. So I hate to sound preachy, and I absolutely hate to be on a soapbox, but this is a battle of ideas that we have to win, because I don't want to live through another version of the Chinese Exclusion Act or the FDR internment camps, possibly because I might be an internment camp. But other than that, I don't want to do that again. There's no reason for it. So I would suggest to you that we need to talk about the value of integration and to talk about how it benefits us economically as well as culturally. And maybe then we can stop having this particular discussion. I know I would be happy about it. So, all right, thank you. And if anybody has any questions, I guess I can take them now. Yes, sir.
So the president has called for extreme vetting for people who are immigrating to the United States. Is there any validity that the process of screening people who are entering the United States needs more scrutiny, or is that just a talking point to encourage fear?
From my perspective, and from everything that I've read, and obviously I am not privy to classified material, extreme vetting is in essence a campaign slogan, a campaign sort of type of rhetoric. Now, if you're wondering what kind of vetting these refugees, like the refugees from Syria, because that seems to be the sticking point with people. Oh, these Syrian refugees, they're all ISIS. So it's important for us to realize that, first of all, the United States didn't take very many Syrian refugees to begin with. So that in itself was a little bit problematic. And the refugees that they did decide to accept went through a 2-year vetting process. It took them, so if you have a refugee, admittance, it took you 2 years to get it, and you were run through Homeland Security, you were run through Pentagon, you were run through State Department, you were run through Defense Department. Everybody did a clearance check. Oh, and one more thing. Most of those Syrian refugees are mothers and children. In fact, the bulk of those Syrian refugees are children. Our government didn't want to give refugee status to young men. They didn't get it. So you might have gotten it if you were an older family man, so you could come with your family, but otherwise, no. So what other vetting could be done? So most are seeing that particular talking point as being code for exclusion, like extreme vetting in that we're not taking any Syrian refugees, and that really does seem to be that seems to be the ultimate goal. Yes, sir.
A question. Not coming from a law background, I was curious, to what extent is it typical when a court decides a case like this? My understanding is that they incorporated some of Trump's rhetoric surrounding the Muslim ban, and presumably that's a legitimate avenue for their interpretation, as opposed to they're not limited to strictly what the statute says, but they can say, well, because this particular president has made these statements, it means something different than if, say, President Obama had passed the same statute.
Well, so that is a reference to the alternative fact, paradigm that appears to be being proffered by some of the president's advisors. But what is happening is that, so there were a couple of problems with the executive order. First of all, it was issued so quickly, he did not even get input from his advisors in this area. So he didn't ask Secretary Kelly, the new Secretary of the Department of Homeland Security, could you look at this and could you make sure that it's going to pass muster? So it was written by somebody who had no familiarity with how these executive orders with respect to immigration needed to look. So when the White House counsel came out the day after the executive order was signed, and said, oh, we're not going to turn away green card holders, the executive order itself actually doesn't say that. It says it actually does apply to green card holders, and that's why it's falling down in the courts right now. So they try to make that argument before the Ninth Circuit that, sure, he didn't mean that, that's not what we meant, and we came out and we clarified, and the Ninth Circuit said, we're sorry, but White House counsel is not the president, and so we have no understanding that anybody else is going to interpret that. So this is the first time that sort of paradigm of alternative facts is falling down. And of course, the president is not too happy about that, disparaging the Ninth Circuit justices, of course. So unfortunately, it does work in popular culture, but the courts seem to be the first place that are sort of saying, no, drawing the line in the sand. And I think it's of note to know that one of those justices on the Ninth Circuit was a Bush appointee. So this is a bipartisan panel, I suppose, if you want to put it that way. And it was a unanimous opinion extending the stay of the ban. All right, well, thank you so much. I really appreciated being here, and have a great day.